Disclaimer. Judge Ron Rangel is providing this podcast and website for educational purposes only, as well as to give the public general information regarding topics related to the criminal justice system. The views, thoughts, and opinions of his guest speakers are the speaker's own and do not represent the views, thoughts, and opinions of Judge Rangel. All rise. You are now listening to Beyond the Gavel with Judge Ron Rangel, educating the public and expanding mindsets. Subscribe on our website, beyondthegavelpodcast.com, or your favorite podcast platform for more of the latest podcast episodes and updates.
Thank you. Thank you very much. Oh, wow. Thank you. Hey, this is great. Welcome to Beyond the Gavel with Judge Ron Rangel. I'm your host. Here we are at Tommy's Restaurant in San Antonio, Texas. I'm going to timestamp it. If this is July the 26th, 2025, 9:30 in the morning, we have a full house at Tommy's Restaurant. Now, this is a Tommy's located at San Pedro and Vance Jackson. I love Tommy's. The ladies in the back, we've had a very long relationship with Tommy's Restaurant. Thank you. Ever since they were across the street from the courthouse. It was one of my go-to places, my favorite breakfast taco from Tommy's. Think about this. Now, I did tell them that they had to bring out the barbacoa for those of us that know how to eat right? My favorite taco is chilaquiles with bacon on corn. Think about that. So if anybody wants to order that, they told me they only have a limited supply left and that they're going to save me a pretty large portion subsequent to this podcast. So in San Antonio, one of the big reasons why I love Tommy's, another big reason, they feature a very good friend of mine who recently passed. I'm going to give him a little shout out. Joe Villarreal. Joe Villarreal is a local artist. If you look around this particular room, if you look in the restaurant, you'll find that there's a lot of pictures prominently displayed that Joe Villarreal did. He just passed, I think, really about a year ago. That's sort of a guess on my part, but he was a great supporter. I always enjoyed seeing him. He always signed by petition. Speaking of petitions, every time I had to run for re-election, and I'm very proud of all the work that he's done. The artistry, I think, really reflects a part of San Antonio that you don't always see in a lot of people's art. So that's really a wonderful thing. Now, as has been mentioned, this is our 52nd episode of Beyond the Gavel. 52nd episode. We have listeners, believe it or not, we have listeners all over the world, other countries. It's been great. We've really enjoyed doing it. I would be remiss if I did not tell you that with me, not just side by side, but frankly, leading the entirety of the time is my former intern, former student, Alana Zariello. Let's give Alana a round of applause. Yeah, I've been teaching about 14 years, 12 years, I don't know. You can't necessarily quote me on the time, but Alana was a student. She became one of my interns, and students would always say, professor, whatever the title was, they would always say, you should go on the radio, right? You would be great on the radio. You would be great. And it was Alana who actually, during the internship, said, we need to develop a podcast for you. So we put it together, spent a lot of time knocking it out. 52nd episode. It's been really successful. Obviously, the podcast could never exist without you, the listener. So thank you very much for being a part of this. We thought it would be great to do this live. And again, I do need to give a shout out. You've already heard from him, but an individual that helped really put this particular concept together here at Tommy's is Rodney Kidd. Let's give Rodney Kidd a round of applause. There's so much fun we could have a variation of his name, but it's actually a very famous name, and he's got some deep roots. Here's what we're going to do today. This is a format. As you walked in, hopefully you put down some questions related to the criminal justice system on a card. They go into a box. They go into some sort of a container. Alana then, the producer of Beyond the Gavel, is looking at them, sort of kind of screening them, making sure that nothing is of a personal nature. We don't want anything to be political. This is Beyond the Gavel. The purpose of Beyond the Gavel is to make sure that we educate the public, we expand mindsets, we bring the courthouse to you. In this episode, one of my very first guests is somebody that I went to law school with, and I've known him for a very, very long time. He came in the other day, said that he would see me today. I told him, Scott, I got to bring you up and communicate with you. As a former guest of Beyond the Gavel, we really need him to come up and answer a few of these questions with me. Scott Simpson is here in the crowd. And you know, a great thing about having Scott Simpson on the show is that he was my very first, in 2009, January 1st, 2009, he was my very, very first prosecutor you were in family violence? Yeah, he was a family violence prosecutor. So we worked together, we moved through a lot of cases together, truly put all of the things that we talk about in action. So hopefully we get to talk a little bit about that today. All right, so let me just start it off like this. This is a community justice conversation. We have no idea when we go through these things, when we record them, whether or not it's going to be a 1 or 2 part episode. Those of you that have listened to Beyond the Gavel, we recently dropped a 2-part episode with Anthony Rodriguez, who did a great job. We talked about the barbecue murder case. And Anthony Rodriguez is an investigator at the district attorney's office. Once we get talking, we just sometimes don't stop. And with Anthony Rodriguez, we just didn't stop. There are others that we've had on the podcast that we just continued to talk with. It was impossible to limit the conversation. So at some point, Alana and I just got together and said, this has got to be a 2-part episode. We don't want to cut any of this out. And so let me start it off by talking about this. There are a lot of misconceptions about the criminal justice system, right? And we know that. And we know that because we hear it. I have talked in my classes about sort of the misconceptions. And part of the misconceptions include things like people believe that there are unlimited resources in the system. People believe that we can always spend all the time and money that we need to handle cases, and every case should be handled case by case in a certain way. People have this concept that the law is very clear. Is that right? I mean, people have this understanding that the law is very black and white. And I've heard people come up and campaign and say, I want to run for judge. And Scott, have you heard this? I want to run for judge. I want to follow the law, right? And that's a very difficult concept when you think about all the constrictions that the law applies. In reality, you think about terms like good cause. What does good cause mean? The word good cause can be applied in so many different ways. For example, I have attorneys that come up and they say, Judge, I want a motion for continuance. And the law says I get one because I've never had one before. This is my first. Or they'll come up and they say, I wanted to ask for motion. I got to get my coffee. I can't do this without my coffee. The law says, right, that, and I apologize for holding this cup of coffee, but I don't have a table around me. And generally, when we do the podcast, it's sitting right next to me. And those of you that have gone to the courtroom have seen the coffee right next to me. I've been doing that since I was in college, 18, 19 years old. Anyway, kind of going back to it. Attorneys sometimes come and say, they can't have a continuance. They've already had too many continuances. This case has been postponed for too long. I'm gonna argue they should not have that continuance. And the response is always this. The law says good cause. Somebody has a right to have a continuance if there is good cause, irrespective of how many continuances you have. Think about this. The defendant is in the hospital. Is that good cause, right? We had a material witness at some particular point in time. He was a detective. He was involved in an auto accident. So he was incapacitated. He was actually in a coma. You remember that detective?
I remember that. And
yeah.
There's always issues. The issue that comes up sometimes is that there's been maybe some earlier frivolous motion for continuances when we weren't hot to go to trial yet. Good cause is good cause.
Think about the word due process. What is due process in several constitutional provisions, the words due process are used. And what does that mean, right? Due process, in my perspective, and the way I like to explain it to folks, it means something that is fundamentally fair. That's due process. So if I were to go around this room and give you a fact scenario, and I were to ask you, in this situation, what is fundamentally fair? Every one of you has a different perspective. Every one of you has a different concept as to what is fair in that particular situation. And the deal with the law is, because it is so vague, and because there are no, frankly, I won't say no, but there are not enough resources to make sure that every case can be handled effectively, because there are so many cases that go through the system, the reality of it is It's humans that apply the law at every single stage, right? So think about a stop. Somebody's driving down the road and the police officer makes a stop and they come over. That police officer is handling that case in his own unique way, making the stop in his or her own unique way, confronting the suspect or confronting the person that they're speaking to in their own unique way. And that is going to develop in and of itself a body of law. The reactions that the individual that's being stopped, the responses are going to be very individual depending on who is stopped, right? Some people may respond angrily, why are you stopping me? Some people may say, I don't have the ability to speak to you without my lawyer. Some people may just be very freely and say, hey, yes, what's going on? Hello, officer, etc. Everybody has their own unique style, and because of that, you get different fact scenarios that the law has to adjust to. So there is a constant adjustment to the law. Now, one of my favorite things to do is speak to an organization called Oasis. We do have a member here. Oasis is a group in San Antonio. If you're 50 years of age and older, then you take this class and pay $6 or so, and you come in and you get to listen. And I've been doing that probably about 12 years now, maybe less, maybe 10 years. I do it every semester and every summer. One of my favorite things to do, because you're talking about really informed individual, like this particular group here. Very informed, excellent questions. We love talking about topics. There's a couple of fact scenarios that I'm going to use that I'm going to come up with right now just to explain the divergence of things, right? Kind of going back to the idea that humans apply the law at every stage. Every prosecutor, like Scott, like myself, we were prosecutors back in the day. Are you still a prosecutor?
Nope, I'm defense attorney now.
Okay. Yeah. So he was actually working in another county.
Yes.
Yes, up until, I guess, a few months ago. Is that the deal?
March 1st, I went to Brick Criminal Defense.
There you go. All right. So a little shout out to Brick Defense. Oh, and before, I got to do one last shout out. Today is National Aunt and Uncle Day. Aunt and Uncle Day. So for those of you that have those aunts and uncles or aunt and uncle figures, make sure that you give them a call. Little shout out to my aunts and uncles that have been very special in my life. My mom had 8 siblings in her family. My father had 7. I got 1 million cousins. We are a South Texas community, basically, the Trevino and Rangelos. So anyway, kind of going back to this. As a prosecutor gets that file from the police agent, the prosecutor is an individual human being. They look at those facts in their own unique way, right? So if you ask people, what's fair in this case, every prosecutor is going to have a different answer for you. Every judge is going to have a different answer for you. Every defense attorney is going to view it and approach that case in their own unique way. Every time you have a witness come on the stand, the way those witnesses testify is going to have an effect on how that case is viewed and how that case is handled. Every time you have a juror, every juror that sits in that courtroom has their own unique way of viewing things. And so, by way of example of how difficult this process is, I've had 2 recent listeners, 2 listeners of Beyond the Gavel contact me. One of them told me this. I have a family member, I think it was an uncle. I have an uncle who was arrested for terroristic threat. That bond was set at $270,000. I don't understand. Why was a terroristic bond set at $270,000? And Scott, you would explain typically what a terroristic threat looks like when it comes to
terroristic threat is simply having the ability to carry out a threat that may cause serious bodily injury or death. So if I just sit there and say, I'm going to kill you, that's a terroristic threat. Now, there's misdemeanor terroristic threats and there's felonies. So the argument is sometimes if I'm having an argument with my brother at the house and I pick up a butter knife and say, I'm going to kill you, now is it an aggravated assault? But terroristic threat generally is a misdemeanor, and that's a crazy high bond for a misdemeanor.
It's a crazy high bond, right? And that's what the listener was telling me.
Yeah.
So we see a lot of this when somebody's going through a mental health episode. Think about that. Somebody's getting arrested, and as they're getting arrested, they'll make a threat to the alleged victim of whatever they're being arrested about, right? I'm going to kill you when I get out of jail. I'm going to hurt you for reporting the police, that kind of thing. Sometimes those terroristic threats are made to the police or the law enforcement agent, right?
On the way down as they're being arrested, and those are felonies.
Those are felonies,
yeah.
Right. Those are terroristic threats.
Yeah.
Or, now when I say they either have a mental health diagnosis and they're going through an episode, or sometimes they could be in the process of being under the influence of intoxicants. Sometimes people get arrested. Now we know 54% of those that get arrested are either drug addicted, they have a mental health diagnosis, or a combination thereof. We call them dual diagnosis in the system. So that's typical. So then I started inquiring a little more, right? So tell me about this. And the listener's response was, I have a family member who's a bonds person. They're a bondsman, right? So they get people out of jail. They tell me that the typical bond is $10,000. $10,000 for a terroristic threat. So obviously they're making an example out of, he believes that they're making an example out of our family member. And I say, okay, so let me get some more information from you. Who was the alleged victim in this terroristic threat at this crazy high bond? She said, well, when President Trump went to Kerrville, he basically made a threat to kill the President of the United States. That makes sense, doesn't it? Doesn't it? So for her family, it's like, this is not a typical, $10,000 bond. Oh my, why are they throwing out such a crazy high bond on somebody? Obviously, we do not want people to threaten the President of the United States. I think we can all agree on that. So there are other examples, but I won't bore you with that just yet. Let's go ahead and start taking some questions from the audience. Right, let's go ahead and see what kind of questions you have for us. Thank you, Alana. Oh, we have plenty of questions. All right. So I'm going to let you, Scott, since you have your readers on,
yes.
I'm going to let you read that.
This one says, criminal justice reform. Do you support alternative to incarceration for nonviolent offenses, e.g. diversion programs, drug treatment?
Okay, so let me tell you what we're doing in Bexar County. So I preside, and I may or may not have said this to the listeners on the podcast, I preside over a criminal district court. Now, for those of you that don't have an understanding, judges have different types of jurisdiction. Some of that jurisdiction is referred to as subject matter jurisdiction. Subject matter jurisdiction means I have the legal authority to preside over certain types of cases. The law says that I preside over felony cases. So we start at the death penalty type cases, capital murder cases. Last week, actually this week, we finished the death penalty writ. When somebody is charged, found guilty, and sentenced to death, there's an entire appeals process that is mandated by Texas law that follows. So we're in the middle of doing that on an individual that was sentenced by a jury. Judges in Texas, earlier in an episode with a guy named Daniel De La Garza, shout out to him, we talked about the death penalty and how it works in the state of Texas. And so judges cannot actually sentence somebody to death. That comes from juries, right? So juries sentence them to death. There's an appeal that followed. So we handle those cases. We handle murder cases. Think of aggravated sexual assault. Think of aggravated robbery, all the aggravated felonies. But we also, on our dockets, handle minimal drug possession of controlled substance type cases. Think of possession of heroin, cocaine, methamphetamine, all the other pills of sorts, prescription type pills that are illegally possessed by somebody. All of those are also, generally speaking, those are felony cases. So I asked folks, what do you think the number one type case do you think we handle in district felony court in Texas? What do you think? What do you think, right? It is absolutely drug possession. They control the largest part of our dockets. So people have this perception that there are all of these courts that can handle all these cases, and if there's a backlog, what is the issue? Because we have all these courts. The reality of it is we do not have enough courts to handle all these cases. We have 10 criminal district courts now. That means we have about 535 cases average per court in district court. Now, these are new indictments. These are not motions to revoke. These are not unindicted cases. This doesn't have anything to do, this is just trial-ready, indicted cases. The grand jury has looked at them. We have them now. Those are huge dockets. So we don't have a lot of opportunity as judges to get to know the particular circumstances of any particular cases. There's something called assembly line justice, when you have certain types of charges where as it comes through the system, you go, okay, this person clearly is an addicted person. They've never been arrested before. They have under a gram of heroin, under a gram of cocaine. Therefore, we should try to find them some services. We have at least 14, I think maybe even 15 now, specialty courts in Bexar County. Thank you. Yes. Now, these specialty courts are very important because even in a court like mine, even in a felony court, 73% of those that are arrested for non-violent cases. 73%. That's almost three-fourths of folks that get arrested. So when you think of a criminal, right? When you think of how you define what a criminal, just that word, what does that mean? We're talking about these folks. In our minds, people have a general tendency to think about violent felons when you think of a criminal, right? Somebody that we need to be protected from. But we know in the system that most people, by and large, most people, a huge, huge majority are nonviolent folks that are committing crimes that we label as crimes, and frankly, they're hurting themselves as a result. Now, there are a significant number of misdemeanor type cases that exist. Most of those are nonviolent. Now, we know that DWIs, family violence cases, those are misdemeanors, but not considering those, huge majority of cases that come in through the system on misdemeanors are nonviolent. And even more than that, the first contact, the majority contact that anybody in society generally will have is with a Class C misdemeanor, a traffic ticket or something of that effect, right? Most of us, if we have contact, it will be contact with a municipal court or a justice of the peace because of a traffic ticket. So, recognizing that most folks are nonviolent, in Bexar County, we have adopted these specialty courts. I started one 5 years ago. We just celebrated our 5-year anniversary of the mental health felony court. These courts are very successful. They're very intensive. Most of the time as they go through this system, if they successfully complete a specialty court that is unindicted, which the felony mental health court does, then that case is dismissed at the end of the term of their specialty court process. And as a result of that, then they get that expunged and it no longer appears on their record. It's very important. Now here's the issue with specialty courts, and this is where sort of I like to talk about this. In the system, the courts have these specialty courts. But we know that subsequent to their completion of the specialty courts and once they're out of the system, that first year is a very dangerous point in time for people that get out of these specialty courts. So what we need, and one of the things which I've been pushing for within the system, I think I've pushed about as hard as I could from the position that I sit in now, is the concept of we need to develop truly within the city and the county. And look, Bexar County and the city of San Antonio are very forward-thinking communities, very forward-thinking. So they do have some resources that we can use. Think of the Haven for Hope. People come in from all over South Texas to come to the Haven for Hope because they have great opportunities for people that have mental health, that either disabled with a mental health diagnosis or they have mental health issues, or they have a drug addiction issue. Somebody's homeless for other reasons, they could use the Haven for Hope. So the Haven for Hope is one of these programs. Within the Haven for Hope, there's a lot of different programs that sort of rent from them, rent space, and they have some of these programs. But frankly, we need to set up a cadre, if you will, a system where we have social workers, case managers that communicate with these people once they're done with these specialty courts to make sure that we have tabs on them, make sure we know who they are, make sure we don't get lost once they leave the system. We keep them in the system. And these folks do things like, let's say they have a food insecurity. They help give them opportunities to learn how to get food stamps. They help them get a job. They help them get clothing when they need that type of assistance. If they want to get a job, they help them get housing. Think of all the things that people need. One of the most common problems that folks have when they're dealing with these types of insecurities, they don't even have a driver's license or an ID. So how can they get a job, right? So a good case manager can help them find a job by getting them an ID or helping them get a Texas driver's license. Scott, do you have anything to add to that?
There's one thing I wanted to add as a public service is that kids, my daughter's here today, so when it comes to crime, people don't know these vape pen cases. They're coming in and so if you're just smoking marijuana and you just have marijuana on you, it's a misdemeanor. But the vape pen case is a felony. I know it doesn't make sense, but that's the way the legislature's categorize it. So we have these kids who are smoking vape pens. They don't know what's in it, and if there's THC in the vape pen, it becomes a felony. They should. I tell kids, just smoke marijuana. Don't do the vape pens, for God's sake. But here's the other thing. They get caught at the school, so because they have the THC at the school, it becomes a third-degree felony, drugs in the school zone. Now, when I was prosecuting in Medina County, we would just turn those into misdemeanors, but the kids don't even realize there's THC. The legislature was supposed to try to fix it this time. They did nothing. about it. There was years ago where they were looking to actually get close to legalizing marijuana a long time ago. Now we've gone in the opposite direction. But kids, everybody needs to know about these vape pens. Don't use the vape pens. Tell all the kids out there, they don't realize what they're getting into. They have no idea what's in that vape pen stuff, and it can turn into a real serious crime.
That is an excellent question. Thank you very much for asking that. I'm going to hand Scott the next question. And just so you know, we have not looked at these questions beforehand, as is typical on the show.
Okay, what are the city magistrates' no contact bonds, and how can you amend them, the 60-day ones? They're talking about the emergency protective orders.
Yes, and I'll let you deal with that one first, Scott.
Okay, all right. So when somebody's arrested for a family violence case, a lot of times when you're magistrated, the magistrate may do what's called an emergency protective order, which they're enforced for 30 to 90 days. The short answer to how do you to fix that is you can't. Okay, that's the short, because when the DA's office isn't going to do that for you. You'd have to hire an attorney to go down to the magistrate to get that amended. So if there's no contact as a condition of bond, which generally comes along with that emergency protective order, that we can get amended. But the emergency protective order is in place still for that 30, 60, 90 days, and the only way to amend it is try to go back into the magistrate's court and get an attorney to do it, and I've never seen anybody successfully do it. I don't know.
No, and if you can imagine, judges and prosecutors are loath to want to go back on those, because there are those situations where, let's say, think of all the different reasons why a victim of a protective order would not want that protective order there, right? Let's say it's a financial situation. We talk about the demographics of defendants, but the reality of it is, think of the demographics of victims. They come from the exact same group of folks. And a lot of these folks don't have that support, don't have that education, they're young, everything else that goes along with some of the things that we've talked about. So those particular individuals then are going through the same pressures that the defendants are with those protective orders. In other words, can they afford to feed their kids? Do they have a place to live that's stable? Is there some sort of emotional connection that maybe somebody is manipulating, right? Think of all the things that happen in relationships. We know that relationships can carry a multitude of facets where an individual who's a victim of a family violence type crime maybe won't want to pursue it. Think of the pressures that they get. We get all these phone calls from the jail where somebody is pressuring a victim on the phone, even though, if you get a phone call from the jail, or if you're a defendant in the jail, the very first thing you hear is a warning that this is being recorded. They still tell, victims things like, look, if you don't show up to court, they're going to have to dismiss my case, right? There's still a lot of that pressure going on, even from within the jail. So as a result of that, judges and prosecutors are really concerned about somebody who's a victim of family violence, who's had that kind of pressure, who wants that case off later than is killed. And I'll give you an example, something that happened to me, and I think I said this early on in the podcast, in one of the early episodes. I was a prosecutor in a place called Hidalgo County. And the reason why I went to Hidalgo, I'd never lived there before. I'm not from Hidalgo County. But as soon as I became a lawyer, I realized very quickly I had no clue what I was doing as a result of something called law in action versus law on the books. Lawyers don't come out of law school knowing how to practice law. That's part of the socialization process that happens within the bar. And so I applied at all of these district attorneys' offices. I interviewed in El Paso. I did not get hired in El Paso. I didn't even get an interview in San Antonio, which I consider to be my home, and I wanted to live in for the rest of my life. But I did get an interview in Hidalgo County. I went down there, one of the best moves I could have ever made in my life. I got to try a lot of great cases. I had great mentors, worked with a great team. A shout out to that particular district attorney, Rene Guerra. He was a really good DA down there. Longest serving DA when I was there practicing in Hidalgo County. But because I was a Child Protective Services caseworker before I went to law school, I did that in the interim for 2 years between law school and college. I was hired in the civil section. The civil section handled family violence protective orders, CPS cases, and juvenile cases. So I had a lady come in. She had a protective order. We counseled her. We talked to her, told her not to go back, left that particular day, and that evening was murdered by her spouse. And that was a devastation for me. That was very difficult for me to get over that. And we go through those situations. Yeah. I've seen Scott go through similar situations. And so as a result of that, you never want to see those things happen. So you tend to be a little tougher on wanting to change any conditions, especially when it relates to protective order. Do you agree with that?
I agree. And so we will change the no contact order to no harmful or injurious contact after things have settled down. I represent people who have family violence cases pending, and they say, "Oh, we need to be back together." I said, "Let's just relax for a little bit. We're not going to change that 60-day emergency protective order. If everything's still going okay, and you guys still want to be able to be back together, then I'll go file a motion in court to change it to no harmful or injurious contact. I mean, you can still have contact, but you can't threaten her or abuse her in any way." And a lot of times people change their minds back and forth as we're going through the process. So one thing I always try to tell people in the criminal justice system, when we as prosecutors and advocates try to tell somebody how to live their lives and say, don't be with this person anymore, well, that's not our business. What I try to tell them is, we're not going to allow people to violate the law. The police were called. The police were involved in this relationship by somebody who called 911. And so we're not going to tell you whether to be with him or not be with him, but we're going to say we're going to prosecute people for violating the law. Is that fair?
That's very good. Yes, and I agree with that. And remember, a protective order is simply a piece of paper, right? It's not going to physically prevent somebody from committing some crime.
If they want to commit a murder, the fact that violation of protective order is a misdemeanor is not going to stop them.
Right. That makes sense.
Yeah.
So, something that just occurred to me. 52 episodes. Scott, you are the very first guest that we've had on the show more than once.
Oh,
Kudos.
really?
That's
Okay,
right.
there you go. All
That's
right.
right.
Do it.
That's exciting. Yeah, let's give it up for Scott. All right, let me pick up the next cue card handed to me by Alana, and I'll read it out. Somebody with very pretty handwriting, but I'm not wearing my reading glasses, so I'm going to have to pull this. Let me try this. All right. Why is someone shackled on a nonviolent crime? Police brutality stopped for nonviolent. And okay, so locally here in Bexar County, for those listeners that are not in San Antonio, I'm reading that, and the last question sort of had some references to local issues. And so on this one, we have recently had a prominent arrest in Bexar County for a DWI. And that individual, now here's a question that I got. So I did get a question from related to the city of San Antonio. It wasn't directly to me, but it was directed at the county, and I'm the one that sort of, in my position as a presiding or administrative judge, I have an understanding as to the magistration process. We could or could not talk about that today, depending on your interest here on Beyond the Gavel and in the audience. But somebody had this perception that somehow or another a video from within the magistration room at the county was leaked to the public. Does anybody have that perception here somehow or another? Okay. And I do see some heads going up and down. So here's the reality of it is. In 2019, when we had to recreate the magistration process here in Bexar County, we did it with forward-thinking processes, best practices in mind. We wanted to make sure that the magistration process was open, that was fair, that the public had access to it. There's something in the Constitution that requires public access to the courts, right? So as a result of that, as we created this process, we do provide a live stream in the magistration room at the county. That's going on 24/7 because in Bexar County, we have 24/7 magistration. The law requires, Sandra Day O'Connor on the Supreme Court, Sandra Day O'Connor wrote an opinion which basically interpreted the Constitution of being brought before a magistrate without unnecessarily delay, meaning within 48 hours. So people get arrested within 48 hours, they have to go before a magistrate. Now that magistrate then is put into the custody of the Bexar County Sheriff. They go into this magistration room in Bexar County. That's where the rights are read. We're going to read you your rights. You have a right to have a lawyer. You have a right to remain silent if you're not, if you're a foreign national, etc. All the rights are read at that time. Then there is a public defender, which we have in Bexar County, always assigned within that magistration process, who meets with the defendant beforehand, We also have pretrial services who meets to determine whether or not this person may have some sort of mental health diagnosis that we need to be thinking about as it relates to diversion programs and trying to figure out how to handle this magistration. Another thing that we've recently started in Bexar County, this is brand new, only a few months in existence, we now have a veterans coordinator in the magistration at the jail, yes. And the purpose of that is that there is a lot of, this is Military City, USA, for those that are not from San Antonio. It's part of what makes our community great. We've had 5 bases, military bases operating at once. I know that there's been a closure and there's always talk of other closures, but we have a rich history in San Antonio of having people from the military live, reside, be a major, major part of this community. And so because of that, when veterans get arrested, we want to make sure that we handle a lot of the times that they get arrested, it's related to their military service and those experiences. And if that's the case, then we're working with the federal government and with the state to divert them in ways that are more assistive. Make sure that we handle those cases right? That's part of Bexar County and what it is that we do. So understanding that, when somebody goes into that magistration process, they belong to the custody of the sheriff. So the sheriff then deems whatever the circumstances are necessary for somebody that's arrested. And if somebody knows that somebody was arrested at the magistration process, we know that it's live streamed. Shortly thereafter, that is put into the cloud. So somebody could go in at any time, look for any date, any time that particular magistration took place and find it in the cloud. It's available to the public, and it's part of best practices. So there was nothing unusual done on that case. It was very, very standard. It was, I'm not going to tell you necessarily what the underlying facts are. I did gather that information last night as part of my administrative role, but I have had that question asked about shackles. Scott, do you have any insight as to why they would shackle somebody at the jail?
I don't have anything about the jail. I do want to say that when you go to the courtroom, everybody who's brought out in the courtroom from the jail is in shackles, and the reason for that is, so say if I'm in Judge Rangel's court, he may have 7 prisoners out there and they put them in the jury box, and we have 40 other people out there who have cases who are on bond and their family and loved ones. Okay, we've had cases where family have attacked prisoners in the box. Okay, so you got 2 deputies in each courtroom keeping track of all this stuff. So everybody who comes out, they're in shackles, so that because if one person does something crazy, then everybody could just get up and run away, and the deputies can't have that. And so yes, everybody who comes out, a bunch of them are out there, as the judge said, for drug cases, but they're in shackles just because everybody who comes out in the courtroom is in shackles for everybody's safety. I know the judge could handle himself if anybody went after him, but not everybody could.
And you know, in the court that I preside over, we really haven't had that sort of an issue. And really, I give it up to the deputies. The deputies do a great job. Really, our Bexar County Sheriff's Office has done a wonderful job in protecting the courthouse and judges. And I'm also told, I don't know how accurate this is, but I have a tendency to diffuse situations in the courtroom. I have a tendency to speak to defendants in a way that is non-threatening. You know, I don't really believe in lecturing unless it's absolutely necessary, and frankly, most of the time it's not. The criminal justice system is not as, I think, chaotic as sometimes people think, but if you walk into a courtroom, it will appear chaotic, because I'll be handling multiple pleas, 3, 4 pleas at the same time, and attorneys and prosecutors and everybody are communicating. You have family members communicating, you have lawyers running around, you have people coming in and out that are being processed. It's just a very chaotic appearing process. And I think that's also a big reason why those shackles are there.
If I could tell a quick story. There was a case that I tried as a prosecutor that got a lot of publicity. She ran her husband off the road. It was on Dateline NBC and killed him. But so that verdict came in at 9 o'clock at night. We had 2 deputies there, and I had 2 investigators there, and her family had about 60 people in the courtroom for that verdict, and she was on bond. But when she was found guilty, she had to be taken into custody. And so that family was going crazy when she was found guilty, and the woman, the defendant, said to her family, "Don't let them take me." And her son was a big dude. They were all big people. They were getting up, and I'm like, oh shit, we're in for it. Okay? And so the deputy, Brandon, if he had tried to, she wasn't going to go back to be taken into custody. If he had drug her back, it would have been on. But he didn't. He did a great job. He came up and he was like, it's okay, it's going to be okay. He diffused the situation, and he turned what could have been like a Donnybrook in the courtroom by being professional and being kind.
Thank you. That was an excellent question. Keep those questions coming. Thank you, Scott. Next question. Supreme Court of the United States just decided, and I did break out my readers on this one. Don't get old. That's my advice to my nephew and my niece. Don't get old, please. If there's one thing that you could do. The Supreme Court of the United States of the United States just decided that countywide and countrywide injunctions, etc., from one federal judge is no longer acceptable. Does that mean each state or region must also seek relief? Now, let me start off by saying this. In the United States, we have something called a dual court system. A dual court, we have two separate courts. It was created back in 1787 when the Constitution was created. And the idea there is federalism, states and the federal government. Dual courts, sometimes in my classes I ask this question, right? Who has the ability to preside over and look over cases? Who's got the higher authority with each other, between a federal district judge and a state district judge? And a lot of times the students will say federal district judge has authority over a state district judge. That's not true. It's a different system. Now, granted, if a district court judge was investigated with a crime, we'll say corruption, or we'll say driving onto one of the bases here in San Antonio, and they have a joint with them, a marijuana cigarette with them, and they're arrested on the base for having that illegal substance, then clearly a federal district judge would have authority over that case. But that's the case, not the court. If a federal judge was charged with aggravated robbery or a family violent assault, then clearly that case would be under the jurisdiction of a state court. But it's not jurisdiction over the court. Where the two systems intersect is one place. That's the Supreme Court of the United States. And so usually the way courts work, they're very conservative institutions. When I say conservative, I'm not referring to political conservative, liberal, progressive. I mean, they're very slow-moving institutions. They only decide a very limited amount, whatever point that they need to make as part of that decision-making process as it relates to an appellate court. They'll say, we had all these questions, but we're just going to answer this one issue because once you answer this one issue, it doesn't relate to these other questions. Now in Texas, back during COVID, I had a case in front of me dealing with a governor's executive order called GA-13, right? So GA-13 said, as an emergency order from the government, it did not go through the courts, it did not go through the legislature. I am going to make it, I'm going to make this order that during COVID, it's an emergency situation, people that are arrested for violent crimes cannot get out of jail on a PR bond. The issue that we in the system had is the definition of violent was so broad. Let's say somebody at the age of 17 years old, which is a criminal charge in Texas as an adult, was arrested for a assault at school. Let's say that person then got into a schoolyard fight and they went through a process called deferred adjudication as an adult, 17, and they successfully completed it. Now later, let's say it is this individual person is now like 65 years old, raised their kids successfully, had a great career, retired, starting to get to the older part of their lives, and now they're charged with a very non-violent, low-level crime. Let's say possession of marijuana, right? Let's say that's a 65-year-old. Because, and they're indigent. They come from an area of the community where they don't have a job, they're retired, they're on Social Security. As a result of that 17-year-old age, when they were 17 years old, arrest for assault, that's considered to be violent. So it was so broad, I found it to be unconstitutional. That order then, from what I understand, was used throughout the state of Texas in similar arguments. They took the order that I wrote, attached it to those types of arguments. And so GA-13 then didn't apply across the state as it relates to my order, but it was used as an argument, which I understand was successfully used in certain circumstances, right? Because you think of violent, who do you think about, right? Which politically is generally used in the media, right? This particular judge is letting violent people go free. And it had nothing to do with violent people going free. It had to do with the definition of violence and how somebody can fall under that. The federal system works the same way. It doesn't affect the states other than from within the federal system. And that's a decision, I think, that was related to an immigration process and whether an injunction nationally would come into play, where the Supreme Court then says, if one particular federal judge finds this to be unconstitutional, then it doesn't automatically make everything else constitutional. It only works in that particular region. That's sort of what's happened. So they never actually touched the immigration aspect of that particular question. Do you have anything to add to that, Scott?
So as it pertains to what's going on now, the one thing, being a prosecutor is a sacred job. We are always supposed to do what's right at all times. Now, what's right could mean something different to everybody else. Actually, in the Code of Criminal Procedure, it says we're supposed to see that justice is done. Okay, so when I see like federal prosecutors making trumped up charges to justify illegal deportations, that upsets me to the nth degree. Because in my experience with Texas prosecutors, I know Texas prosecutors get a bum rap, but I've taught at prosecutors around the state. They're a good group, even from conservative districts, liberal districts. They all want to get it right. But that doesn't mean that you may agree with what they think proper punishment is. But when we start trying to justify bad decisions by trumping up evidence, those people shouldn't be prosecuted anymore. That's what I'll say.
All right, let me get the next question. You always hear about being tough on crime. Why is fairness more important?
That's my question. I wrote that.
I like it. I thought I recognized that handwriting. Well, Scott, you had something in mind. Let's let you answer that one first.
So I see that everybody who runs for judge or DA, they're not everybody, but a lot of people, they're particularly when you get out to the rural areas, they'll say, tough on crime, tough on crime. I'm like, and when I first left the DA's office, I worked with a lot of police officers, have a lot of police officers who still talk to me. I handled all the murders in Bexar County for a period of time. And so all the detectives would be like, why are you guys so technicalities? We need to be putting all these people away. But when I left the DA's office, where did a lot of my business come from? Police officers, family and friends, or people at the courthouse. So everybody wants everybody to be tough on crime until it involves one of their loved ones. Well, we can't have two different standards. It's got to be fair for everybody. So when you're voting, vote for the judge or the DA who says they're going to be fair, even though politically people are going to say, what do you mean fair? We need them to be tough. But remember fairness. That's all I'll say. I'm not running for office.
All right, and so from the Beyond the Gavel standpoint, let me explain it like this. So there is a lot of money that comes about with the concept of us being afraid in society of crime, right? What, generally speaking, is the first thing that you read or that you see on TV when it comes to reporting? It's that big, ugly crime story, right? And so as a result of that, people want to pay attention because there's this fear. Apart from media accounts and apart from all these other concepts of how to bring money into whatever the business is, think about things like ring cameras and bars on doors and locks on cars, and there is basically a big business that is related to trying to keep us safe. So there is this fear. I love to ask my students at the beginning of every semester, tell me what you think. Is it better to let 10 guilty people go free or one innocent person go to prison? Which way should our system operate? And generally, it tends to be about 50-50 among my students. And then when we get into that discussion, we start talking about why. Invariably, it comes up that the answers that they focus on are, we don't want to let that murderer go free. We don't want to let 10 people that committed sexual assault or crimes against children or pulled out guns on people at night as they're getting into their cars to go free. But then we start talking about the statistics as to who gets arrested, and that is a very tiny percentage. We're talking about a percentage of one of those 10 theoretically is charged with a violent crime, right? And so when you look at it that way, when you frame it in that way, people have a tendency to change their mind. But we have this concept, and we're sort of trained, we're sort of conditioned, and I don't like to use that word particularly, but we're sort of trained to think of crime in a way that scares us. And there's a reason for that. It's a visceral part of our human way of, right? It's the way we feel about things. And so as a result of that, people like to hear toughness on crime. But, all right, so I'm going to give you a little personal background information. When I was in college, so I've always been a big reader. I've always loved to read. And I've always loved to read when I was young. I loved to read things like Sherlock Holmes. I like to read the classics, Emily Bronte, right? Think of all the classics. Those classics come from England. So my dream was to study abroad in London. So when I was 23, I got to do that. My last semester in college, I studied abroad in London. And over there, we had, people on the left, people on the right. We had conservatives, right? And so, and for those of us that are listening to this on Beyond the Gavel, the people in Europe, people that are on the far right are way out here to the right. And people that are on the far left are way, way over here. In the United States, right, and 80% of folks fall within this gap. And for those that are listening, it's pretty wide. I'm trying to show the wide distance between my hands. In the United States, that 80% is really right here, very narrow. We all kind of feel the same way as it relates to crime and punishment. I'm not talking about other political issues. I'm referring to crime and punishment. We all feel the same way. I think all of us want the few people that are violent in our society, the few people, we want them punished, right? We want to be safe from those people. If somebody is a violent person, we want them incapacitated. We don't want them out to hurt our grandparents and our children and our loved ones and ourselves. We want to be safe. But are we keeping people safe if we're incarcerating non-violent people? People who are not hurting others. And I think all of us agree that if somebody has certain factors that make them nonviolent, where you can make society safer by helping them become a better person, putting them in the system, maybe going through a specialty court, taking these classes, helping them in whatever manner that is on the personal side, because there are underlying factors of crime. If the underlying factor that somebody is committing a crime is because they're an inherently violent person, that's one example, that's one extreme. But if somebody is underlying causes of crime being affected by things like no health insurance, so as a result of that, they're using drugs illegally because they're trying to self-medicate and they're getting arrested, or they're committing a theft because they're from HEB, I see this all the time, right? If somebody commits, I had this case in front of me, and I'll give you an example as to how this works. An individual this is a great example. An individual was mentally ill. When I first became a judge, I took a tour of the Bexar County Jail. And as I walked through it, I walked by a padded cell. And there was a gentleman in there that was in a straitjacket. And the folks at the jail were saying, oh, that's Brian. Brian's he's got a schizoaffective disorder. He's mentally ill. He's constantly getting arrested for drug use. So he had 2 priors in his background. Those 2 priors were related to drug possession cases. There were 3rd-degree felonies, meaning there was a little bit over a gram on each case. He was put on probation. Brian obviously could not successfully complete probation. So Brian was subsequently revoked and did a short stint in prison for each one of those 2. Now in Texas, we have something called 3 strikes and you're out, right? You know what that means. So Brian was found at actually very close to here, at the HEB, very close to where we're at now. He was in a parking lot having an episode. Police officers approach. If you know anything about schizoaffective disorders, it's very difficult to touch them while they're going through an episode, right? So obviously, you can't charge somebody who is going through, let's say somebody, and I can't think of the term off the top of my head, I am getting older, but somebody who's epileptic, right? Somebody who's having an epileptic seizure, in the middle of the seizure, they strike out and they hit somebody in the head. Theoretically, that could be an assault, but it's not because there's no intent to hit that person. Right? It's an involuntary act. So that obviously is a defense. There was no intent. With other folks, think of somebody who's going through an episode, if they have their wits about them. Brian had a police officer touch him, basically trying to get his attention, and he elbowed the police officer in the chest during that arrest. He was in charge with an assault, which is a Class A misdemeanor, but because it's against a public servant, it's now enhanced to a 3rd-degree felony. And because he had 2 prior 3rd-degree pen trips, minimum 25 years up to 99 years or life. Now, personnel within the justice system, we're looking at this case. The district attorneys offered him a year in jail because he had had a year in jail by this time. He went through the incompetency evaluation. He went through the sanity evaluation, which is all very costly to society. But Brian was found to be competent. He came into the court. He said, no, I'm not going to take this case. I'm not going to take this plea. I'm going to fight this. I want a jury trial. Jury found him guilty. And as a result of that, he got sentenced to 25 years in the penitentiary. Now, think about this for a second, if Brian would have accepted that plea bargain of 1 year in jail, time served, he's out, think about those media headlines, right? Think about how that sounds, right? Habitual offender charged with assaulting a police officer, got time served. Think about that. And so as a result of that, these types of issues do come into play within the justice system in the sense that legislators use that against justice personnel, prosecutors, defense judges, and they say, look at how the system is soft on crime. Look at how the system allows violent people. Brian, because he committed an assault, is considered now to be a violent offender, if that makes sense. Somebody's in custody, the end result of their case is going to be much, much worse statistically than it is when they're out of custody, which makes sense, right? You can't do all the things that you need to do to prepare for your case if you're in custody. So it affects not just the media realm, it affects not just how we feel, it also affects how criminal justice personnel are perceived. When they're trying to seek justice, they're oftentimes perceived as being soft, when the reality of it is they're taking this case by case and trying to figure out what is fair in this particular situation. That's a very good question. All right, we have time for 2 more questions. Time goes by really fast when you're having fun, doesn't it? I'm really enjoying this. And I really want to thank Scott. You know, when we put this thing together, Beyond the Gavel is really, I always have a guest. I always have a guest. And I was very fortunate that Scott came up the other day and said that he was going to be here because I thought it was a great opportunity to have our guest. I'm going to let you read this one, Scott.
How do you plan on supporting the development of the next generation of prosecutors? Ooh, there you go. There you go. There you go.
All right, so this is no knock on anybody. So from my perspective on the bench, prosecutors need to be developed. Prosecutors need to be trained. Prosecutors need to know how to walk into a courtroom, feel comfortable. There are some district attorneys' offices where they're prosecution officers are sort of siloed, meaning they don't really communicate with others outside of their own unit or area. There is a perception that I have that I think I would love to see misdemeanor prosecutors hooked up with felony prosecutors through something which we did have back in the day called sister courts. So you have, rather than having a group of prosecutors that are felony prosecutors in the 379th, and then you have a completely separate group of prosecutors that operate in county court blank, those should be one unit working together, where frequently a felony trial will bring up one of the misdemeanor prosecutors to participate in that trial, to learn, to grow, and frequently you can have a felony prosecutor work in that misdemeanor sister court to teach and to help and to grow, to learn. Prosecutors, generally speaking, come out of law school looking for experience. They want to be in a trial court. That was my experience, right? When I first became a prosecutor, because I was in the civil section, within 2 weeks, I was in a attempted murder case, trying that case all by myself. And I learned. I did get a conviction, but I learned so much. And there was a felony prosecutor that sat in there, watched me, encouraged me, gave me all sorts of advice during the trial. The best way that I developed in terms of understanding how a case progresses is to make sure that I have that experience. Now, also, prosecutors should have the ability to have discretion. Case by case, it's a case by case, but I think prosecutors should have the ability, let's say that you're a misdemeanor prosecutor, a new prosecutor, and you're looking at a case file, you should not run everything through somebody up above you. You should have the ability to make decisions in the courtroom. Now, we do have a new system in Bexar County. It does allow prosecutors to keep notes internally, One thing that is currently not being done that I would love to see different is anytime a deal is made that sounds on its face a little different than what society would expect to be the norm, to explain it. Explain it into that system. Explain, we had a witness that when we brought that witness in an interview, she told us A, B, and C, did not want to be a part of this, did not want to be traumatized by having to go into court. Her family did not want to be a part of this, or they consented to something, or we can't find a witness, or this witness didn't come across believable to us when we're testifying. Put those things in there. That way, the district attorney's office, that way, the elected DA has the ability to say, this is what my prosecutor looked at. They determined that it was fair. I completely support my prosecutor. We're a team. We're working together as a team to help keep our community safe. What do you think, Scott?
So the issue that Judge Rangel brought up is they've put more brass in at the DA's office so that the misdemeanor prosecutors not only have their own chief, but they also have a deputy chief. So in the old days, misdemeanor prosecutors, we'd get a guy. When I started with Steve Hilbig as the DA, that's how long ago I started. Not as long as Oscar's been doing it, but all we had is a sheet with guidelines like, here's what a typical plea would look like. And then we were just turned loose and we made our decisions, and sometimes we made bad decisions, and our chief would say, I would have done it differently. Now what happens is they're not making the decisions. They're running everything, as Judge said, by their deputy chief or their chief, and you have the added problem that during COVID, none of these misdemeanor people got trials because we weren't going to trial. Because you might not like hearing this, but misdemeanors are for the new prosecutors to make mistakes. It doesn't matter if they screw up something on a misdemeanor necessarily. They're not serious, but you got to learn a misdemeanor. Right now we have people who've made it up to felony who haven't had the opportunity to use their own judgment, and now they're being turned loose. Okay, so I would say, you have the misdemeanor prosecutors use their judgment, and then if we see people constantly making bad judgment decisions, those are the ones we need to get rid of, right? But if they have to come and run everything by somebody, they're not developing, and so then they get up and now they don't have as much supervision when they're doing felonies, and now they're left without the judgmentally impaired at that point. So,
and what we're giving you are basically frameworks for how that would operate. The reality of it is it's very detailed. There's a lot more detail. It's possible in the near future that details will be available to you to peruse and to read. All right, now we do have a question for, thank you. All right, so we're gonna have a hot seat question. We're gonna bring someone up. And if you can introduce yourself, you can give us a little bit of background information, and then you can ask your questions. So.
Yes, sir. My name's John Stallings, and first of all, I was in the criminal system many years ago. And the reason I'm here because I know this judge directly on a good thing. And one thing I want to say, I was in his court, and I had a judge, a court-appointed attorney, and we had to go to court. I had to go to jury the next day, and he wanted to dismiss my case. I'm like, oh, Judge, no. I was upset, I was scared, and so it was me and this attorney debating in his courtroom. No, you ain't gonna do that. You're sorry, Judge. But anyway, he kept the calm. He said, Mr. Stallman, we'll give you a new attorney, and your case will have to be dealt with tomorrow. So I give him kudos for all the good works that he's doing to help people out. Okay. Now, one thing, the questions I have is expungement record. When someone goes to jail, serve their time, and why come the state of Texas, unlike other states, do not automatically clear that expungement record? Because it's going to be a hardship for somebody to try to get a job, get housing. It's like a recidivism rate. You're going to come right back in jail because you can't do anything. That's one of my questions. The next question would be, and I'll say this, also in 2004, 2005, I went to Dominguez. The day I got out, I got married to that young woman back in the back. We've been married now 20 years. That's my son, my stepson I helped raise.
Wow, congratulations.
He's getting ready to graduate from St. Mary's with his master's degree, Antonio, and he's very smart, presidential scholarship and all that good stuff. So the thing is, on that one, the other question would be, when I got out of jail in 2005, I went to the court because I had enough back time. I have filed a non-return and habeas corpus and all that kind of stuff. I helping all the inmates get their stuff. And then I went to courtroom. I went to look for my record, wasn't there. So anyway, I appealed to the Supreme Court. They came back and said I had enough good time not to go there for all that time. But now I'm trying to get that record cleared. I got everything else working to be expunged except that. Is there any secret solution that you can do? Thanks.
All right, so that kind of answers a couple of questions for me. I see that Scott sat down, so that answers a couple of questions for me. So now it makes sense to me who has been providing all that information to those inmates at the Bexar County Jail. Because when they come in, when they come in with those forms and they say things like, okay, I have this right, I have that right, I'm thinking, who over there is doing that? Who's the lawyer that is in that particular So thank you for answering that, sir. So first of all, thank you for letting me know that. It is always a joy for me when I hear things like that, and it means a lot to me. A lot of people ask me, okay, how difficult is it to have your job? Because we see a lot of violence in the courtrooms, right? Nowadays, we see all sorts of things that we did not see before. A couple of episodes past, I talk about a situation that really had an effect on me. It really affected me. I dreamt about this during the trial. Very painful to see. A young 16-year-old girl that had been shot. Police officer arrives at the scene. He is wearing his body cam. So all of us in the courtroom saw this as part of the evidence. And we basically saw the police officer trying to save this young girl's life. And she passed on video. That was a very, very difficult proposition. This gentleman had shot several of people that were at this particular party, all young people. So we go through these experiences and we see these things. And people tell me it must be very difficult for you to be able to handle that type of case, those types of caseloads. How do you sleep at night? Do you need therapy? All those kinds of things. And the reality of it is, do any of you, now, this is a room, it's a mixed crowd. Do y'all remember a TV show called Quincy? Yes, excellent. That was one of my favorite shows when I was a boy. And Quincy was basically a show, I think it was in the 1970s. I'm going to date myself. It was in the 1970s where it was a medical examiner, a physician. Police agents would bring over some sort of, like a body, a cadaver. He would look at it and he would solve crimes through his work as a medical examiner. And there's this opening setup in the show. I think it happened every single show, where Quincy's talking to this police agents and is explaining, okay, I'm opening up this body, this is what I see. And one by one, the police officers are passing out because they become ill from looking at this thing. Quincy, meanwhile, is eating a sandwich as he's doing this, right? So it's kind of the same, I think, for those of us that work in the system. We sort of become, not completely, but we kind of become desensitized over time of everything that we see. The first autopsy that I viewed made me sick for about 2 weeks. I was a prosecutor in the Valley. Now, it's just another course of the business. The hardest thing that I do, the thing that really does make me struggle, emotionally, actually, if you want to be honest, is taking somebody in front of me who's clearly a good person, but they committed some sort of act. I'm thinking about that one individual, 18-year-old child who had a car, got intoxicated, got into a wreck, and killed 4 other young people as part of this. And I had to sentence this young man to prison. And to see him look at me, to hear his voice, to hear what he went through that morning celebrating his 18-year-old birthday, not having any concept that he would ever be the result of somebody else's passing, now going to prison for a very long time as a result of this action, those are the hard things to do. So it's never easy to send people to prison. Well, I take that back. Sometimes it's necessary, but that really is the harder, that's really the harder part of the process for me. Now, let me give you a couple of statistics as it relates to prison and how this cycle doesn't necessarily get better by incarcerating every single person that comes before the court, right? If somebody is incarcerated and they have a child, there is a 15 to 20% chance that child will ever get out of the bottom quintile, the bottom 20% of society socio-economically, right? 15 to 20%. If somebody is in poverty already, if they're in that bottom quintile, they have a 45% chance that they'll get out of that poverty level at some point in their lives. Think about that difference, 15 to 40, right? We incarcerate as a society in the United States. I think one out of every 6 people that black folk, Hispanic folk, 1 out of something like 25, 26, 1 out of 57 white folk. That's who we incarcerate. So you can see sort of this systemic, right? There's a systemic thing that happens where once somebody is involved. Now think about this, being a child and having the parent incarcerated, the rates significantly skyrocket of high school dropouts, right? Having problems in school, getting arrested themselves. They're 6 times more likely than the average to go to prison themselves, right? So there is a definite cost to society when we incarcerate somebody. Recognizing all of those things, when they go into court and they have their case resolved, sometimes people come in and they say, my case should have been expunged. An expunction should be filed. The law has been clarified. Right before I became a judge, there was a Texas Supreme Court decision that came out that clarified the law that said that if there's probable cause in your case, meaning you got some sort of probation, you cannot get that case expunged. If there was a grand jury that found probable cause, you cannot get that case expunged unless it was dismissed in a jury trial, right? Or otherwise dismissed. The law does not allow you to get an expunction if it's dismissed short of a jury trial within a certain time period. Depends on what you got charged with. So that's very difficult. So it makes it tougher to get an expunction nowadays than it used to be. If somebody was on some sort of deferred adjudication, meaning they went through some sort of probationary process but did not get that ultimate conviction. So by operation of law, that case was ultimately dismissed through the successful completion of supervision. Then, in certain circumstances, that case can be non-disclosed, meaning a motion can be filed, and it could be granted by the court, where they would seal that record, almost akin to a juvenile sealing. It would be sealed, but certain entities would always have the opportunity to view it, like the court system, like the state system. Let's say somebody wants to be a lawyer. Let's say somebody wants to be a plumber or an air conditioning person and get a state license. The state would have the ability to view that particular arrest then at that point and recognize that this person had been in some sort of supervision. So it's a difficult process. That's how it works. We won't get into the details here on Beyond the Gavel, but thank you very much for coming up and asking that question. Okay.
Yeah, my name is Carlos Antonio Raymond. I'm a Vietnam veteran, and here it is. We have a scenario where an individual served time in Vietnam, got out of the military and committed crime. Okay, a felony. What is the line of compassion there as a judge? Where do you draw the line, considering this person served and trained in Vietnam, and now he committed a crime and he's in jail? Where's the line of compassion right there?
That is a great question, and I'm going to include it with the question that I just picked up that was on the top of the list. How do you handle viewpoints that differ significantly from your own? Those two kind of work hand in hand, and I'll explain why. One of the things that people have a lack of understanding about is this concept as to what is fair in any particular case, right? So if you ask, well, I'll break it to you like this. I had a defendant one time in the courtroom who was charged with a crime. The parent got up and testified on this person's behalf and said, my child is a loving child, a good child, you should give him probation. The victim came up and said, this is the effect that this crime had on me. It affected my life very severely. You should give this person prison time. Two very different concepts as to what justice means in that case. Now, I had another case. Imagine this. If a defendant were to punch somebody in the face, just a flat out punch them in the face, they fall down, they get up and they run, that is a Class A misdemeanor assault, meaning they can't go to jail for more than 1 year. That's the maximum term. However, we had a jury trial, very interesting case. An individual punches somebody, fall down, but as they get up, they stumble. They're stumbling still from that hit in the face, and they stumble into a street, fall over a curb, get hit by a passing car, and die. That person is now charged with that person is charged with a manslaughter. That's a second-degree felony. It's the exact same action, but something was different, right? Somebody driving intoxicated in their driveway, let's say they have a long driveway or a ranch road, that's not a DWI because it's not a private. This action is the same, but it's a private residence versus a street. Think of, I can give you a million examples, right, as to how an act could change. And this is an example I brought up to my classes. Think of a theft, and I brought this up on one of the episodes. Think of a theft. Somebody is walking out of a store, and as they're walking out of the store, they see a piece of gum on a rack. They grab that gun, put it in their pocket, and they walk out. That's a very low misdemeanor theft, a Class C theft, right? Think about somebody being here at Tommy's, and there's a woman who has a purse, very private, and as she's looking in a different direction, somebody besides them reaches into that purse, pulls out that piece of gum, and steals that gum. It's the exact same theft, right? But is it? Is it different, right? It's a different characteristic that somebody exudes or exhibits when they take something from an H-E-B counter than it is when they're going into somebody's private purse, their possessions. So every case, you have to look at case by case. It's one of the things that as a judge, I have always argued that judges need tools, prosecutors need tools to do what's fair in every single particular case. You have to look at all of it. And so sometimes I have come into court and let's say it's a sentencing day. I'm gonna look at some case files and I'm gonna determine a sentence. And I look at that sentence and I'm thinking, oh, this person more likely is gonna go to prison. And then I see them across the bench and they talk to me and I talk to them and I'm thinking, this person's presenting very differently than what's on paper. Sometimes you see it the other way, where you're thinking, oh, this person clearly should get probation, but then you talk to them and you're thinking, I'm getting a very different feel, right? There was a listener who about a week ago contacted me, and what the listener said, they were a little upset. They were like, I don't understand why this gentleman in Idaho, I wasn't familiar with the case, but a gentleman in Idaho kills 4 people. Clearly he did this. It was a death penalty case. Idaho does have the death penalty available to them as a sentence, but the DA made a deal where this person's going to spend 4 consecutive life terms in prison. Why didn't this person get the death penalty? It was such a clear case. I said 3 things, actually. The first thing is this. You never know how a jury is going to proceed. You never, ever know. Any of you listen to the barbecue murder podcast episode that we dropped a couple of weeks ago? Thank you for listening. In that case, there was a co-defendant. There were 2 people that killed this individual, a heinous crime. An individual was lured over to a home, hit over the head by baseball bats, basically murdered in front of his girlfriend. His body was dismembered, placed into a barbecue pit to dispose of the evidence. Heinous crime. A lot of people were paying attention to this. I had a lot of contact from people through my email and everything else. Obviously, I could not respond to any of it because I'm a sitting judge sitting in on this case. We had a jury trial on a co-defendant. This gentleman had tattoos all over his face. Now, this case was also featured on Netflix, on a Netflix TV show called I Am a Killer, Season 6, Episodes 1 and 2. I have not seen it. Believe it or not. And looking back, I'm thinking maybe I should not have declined of being interviewed. Maybe I could have been a national star. Who knows? So in this particular case, we had a jury trial for this defendant that had tattoos all over his face. The media is watching this. People are watching this. Very high profile. Jury deliberated for a very long time, a couple of days. They come back after several different times telling me we are never going to reach a consensus. It's got to be unanimous verdict. All 12 have to believe that he's guilty in order to find him guilty. We're hung. So I found a hung jury, meaning mistrial. I went to the back. I thanked them very much for their service. They told me that it was 11-1 guilty. 11 individuals said, we believe this is guilty. One person said, and she gave her reasons why, not guilty. I'm never going to find this guy guilty. I'm not going to believe it. So the 11-1 guilty. We tried that case a few months later. The exact same evidence, the exact same people. Different jury. They came back very quickly, unanimous, not guilty, right? People were outraged. They were upset. The point that I'm making is Every single time you have a jury trial, you never know how a jury is going to look at it. You never know what personality is going to be there and what they're going to see. I am always amazed when I go to the back and I speak to jurors and I say, hey, what did y'all get out of this? What did you see? The things that they tell me they debate, I'm like, wow, I hadn't even considered that. 12 different people with 12 unique ways of looking at things is an amazing part of our system, right? So it's always a risk. Scott knows that because Scott and I tried a lot of cases together, right? He was a prosecutor and as a defense attorney and me as a judge. So we know that is always a risk. You never, ever know, number one. Number two, even if the jury finds him guilty and believes 100% that all of these things happen and there's ample evidence, for any reason whatsoever, they can say, we don't want to give this guy the death penalty. We want this person to get life in prison without parole. They could just feel bad for something that happened to him in his youth. They could feel bad for the way his father treated him or the way his mother treated him or the way that he was raised without any sort of support. You never know how a jury's going to look at that, right? Number two, just because he's found guilty does not mean that this person is going to get the death penalty. Number three, and this is an interesting aspect of it. I told you earlier in this episode that I was going through a writ on the death penalty case. Jury found this guy guilty over 3 years ago. This is the very first writ. We have spent hundreds of thousands of dollars on experts. The appeal process, which is automatic in Texas, it's automatic, nothing anybody can do about it, requires that these types of things happen, where other parts of the system, defense attorneys then, engage with experts from all across the country to come in and say, if this other piece of evidence would have come in, we believe that maybe he would not have gotten the death penalty, right? This is all part of the process. And so we as a society in Texas spend a significant amount of money more handling a death penalty case where somebody's found guilty and sentenced to death than if somebody's in prison without parole for the rest of their lives. People have this concept, why are we spending this money supporting them in prison? Those conditions are not very good. I can guarantee you that. But when you look at the cost, it's a consideration. Is it the only consideration? No. The point that I'm making is you have to look at all the considerations when you're dealing within the justice system. You got to look at everything. So everything that comes in, including the military service that somebody has, that is a consideration. There is no determinant factor. I like to eat. We're at Tommy's. I'm going to enjoy one of these tacos in a few minutes. I can tell you this. You get a soup, right? You get a bowl of soup. Every time you add some little ingredient inside that soup, it's going to change that flavor. So at the end, whatever the flavor is, when you're done with that soup, whatever the flavor is, whatever the feel is, whatever the right way to go is, whatever justice dictates at the end of getting all the evidence, and all of it matters, that's going to be the end result of that trial. So that's about the best way that I can thank you for that, Mr. Raymond. Thank you for asking that. So I am being told by Alana that we have reached the end of another episode of Beyond the Gavel. Thank you all so much. Thank you all so much for being a part of this. It was fun for me. I had a great time. I genuinely appreciate every one of you for participating. I thank you, the listener. Without you, the listener, we could never have reached 52. I look forward to a lot more episodes of Beyond the Gavel. Until then, remember, you can always go on beyondthegavelpodcast.com. You can like, you can follow. Please have those questions come in. We love answering those questions. We'll see you in 2 weeks.
You've been listening to Beyond the Gavel with Judge Ron Rangel. Join us in the next 2 weeks where we are educating the public and expanding mindsets. Head to our website, beyondthegavelpodcast.com, or your favorite podcast platform to subscribe to the latest episodes and updates.